Namaskar, welcome to our another video designed specifically for legal professionals, law students, and anyone keen to deepen their understanding of legal frameworks. Today we are going to do a quick revision in a simple language. You may download complete notes from the description link or from the first comment of this video. Let's start. The topics which all are covered in the entire notes are as follows.
Hey everyone, welcome back to my channel. Today we are diving into the fascinating subject law of corporate finance and securities regulation. Don't worry, I'll keep it simple and fun. You can think of me as your guide on this journey. Let's start from public issue of shares and share capital. Public issue of shares. A public issue of shares is when an unlisted company offers its securities to the general public for subscription, typically to raise capital. This process is heavily regulated to protect investors. Prospectus. As per Section 2, subsection 70 of the Companies Act 2013. A prospectus is any document described or issued as a prospectus, including a red herring prospectus, shelf prospectus, or any notice, circular, advertisement, or other document inviting offers from the public for the subscription or purchase of any securities of a body corporate. Purpose of prospectus. It's the primary document through which a company solicits investments from the public. It provides material information about the company, its business, financial performance, risks, and the terms of the issue. Contents of the prospectus. Section 26 of the Companies Act 2013 and SEBI, issue of capital and disclosure requirements. Regulations. 2018 ICDR regulations mandate extensive disclosures. Key information of the prospectus includes financial information, audited financials, profit and loss, balance sheet, capital structure, objects of the issue, risk factors, management details, litigation and defaults, underwriting arrangements. Let's understand about the types of prospectus. Red herring prospectus, RHP. Section 32, California 2013. A prospectus that does not include complete particulars of the price or the quantum of securities offered. It allows a company to gauge market demand before finalizing the price and issue size. Shelf prospectus, Section 31, CA 2013. Issued by a public financial institution or a company, it allows for multiple issues of securities over a certain period without a fresh prospectus for each issue. A separate information memorandum is filed for each subsequent offer. Deemed prospectus, Section 25, CA 2013. Certain documents through which offers for sale of securities are made to the public are deemed to be prospectuses. Abridged prospectus, Section 33, CA 2013. A memorandum containing salient features of a prospectus. Every application form for securities must be accompanied by an abridged prospectus. Registration of the prospectus. A prospectus must be dated and signed, and a copy thereof must be delivered to the registrar of companies and also for registration before its publication. Section 26, CA 2013. Remedies for misrepresentation in prospectus. Misrepresentation in a prospectus can lead to severe civil and criminal liabilities to protect investors. Civil liability, Section 35, CA 2013. Liability for damages. Any person who has subscribed for securities on the faith of a misleading prospectus may claim compensation for any loss or damage sustained by reason of the untrue statement. Who is liable? Every person who is a director of the company at the time of issue of the prospectus. Every person who has authorized himself to be named and is named in the prospectus as a director or as having agreed to become a director, either immediately or after an interval of time. Every promoter. Every person who has authorized the issue of the prospectus. Every expert who has authorized the issue of the prospectus containing an untrue statement purporting to be made by him as an expert. Defenses available in this case. A person may escape liability if they can prove they withdrew their consent before the issue of the prospectus. The prospectus was issued without their knowledge or consent. After the issue, they became aware of the untrue statement and gave reasonable public notice. They had reasonable grounds to believe and did believe that the statement was true. Now learn about the criminal liability. Section 34 CA 2013. Any person who authorizes the issue of a prospectus containing an untrue statement shall be punishable with imprisonment for a term which shall not be less than 6 months but which may extend to 10 years, and with fine which shall not be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud or with both. Defenses available in this case. Similar to civil liability, a person may escape if they prove they withdrew their consent or that the prospectus was issued without their knowledge or consent. Rescission of contract, Section 36, Indian Contract Act, 1872, read with general principles. An allottee may rescind the contract to purchase shares if they can prove that they were induced to subscribe by a material misrepresentation in the prospectus and they acted promptly upon discovering the misrepresentation. Action for deceit. An investor can sue for damages for deceit if they can prove that there was a false statement made knowingly or recklessly with the intention to induce the investor to act upon it, and the investor suffered damage as a result. SEBI and Stock Exchange Guidelines. SEBI, Securities and Exchange Board of India, is the primary regulator for the securities market in India. Stock exchanges like NSE, BSE also play a crucial role in listing and trading. SEBI, issue of capital and disclosure requirements. Regulations 2018, ICDR regulations. These are the most comprehensive regulations governing public issues. They cover eligibility norms, means, conditions a company must meet to make a public issue, AG, net tangible assets, net worth, track record. Disclosure requirements means detailed disclosures in the prospectus to ensure transparency. Pricing means regulations related to book building and fixed price issues. Underwriting means requirements for underwriters. Allotment means fair and transparent allotment procedures. Listing means requirements for listing securities on stock exchanges. Post-issue obligations means continuous disclosures. Role of SIBA, vetting of prospectus. SEBI reviews the draft of a document DRHP to ensure compliance with regulations and adequate disclosures. However, SEBI does not approve the prospectus. It merely issues the observations. The responsibility for true and fair disclosure lies with the company and its board. Investor protection. SEBI's regulations are primarily aimed at protecting the interests of investors by ensuring they have access to accurate and timely information. Market integrity, ensuring fair and transparent market practices. Stock exchange guidelines, listing agreement or regulations. Companies desirous of listing their securities must enter into a listing agreement with the stock exchange and comply with its listing regulations. AG, SEBI, Listing Obligations and Disclosure Requirements Regulations 2015, LODR Regulations. Pre-listing requirements, due diligence by the exchange, verification of documents, post-listing obligations, continuous disclosure requirements, corporate governance norms, timely dissemination of price-sensitive information. Trading and settlement. Stock exchanges provide the platform for trading and ensure efficient settlement of transactions. Share capital. Share capital is the money invested by shareholders in a company. Let's learn about the nature and kind of shares. Nature. Shares represent the ownership interest in a company. They are movable property, transferable in the manner provided by the Articles of Association of the company. Section 44, Companies Act 2013. Kinds of shares. Section 43 CA 2013 are as follows. Equity share capital with voting rights. Most common type carries voting rights on all resolutions with differential rights as to dividend, voting or otherwise. Allows for flexibility in capital structuring, subject to conditions prescribed by the companies. Share capital and debentures. Rules 2014, e.g. dividend payout history, no default on financial statements. Preference share capital. Carry a preferential right to receive dividends at a fixed rate or amount and a preferential right to repayment of capital in case of winding up. Generally, they do not carry voting rights except in specific circumstances affecting their rights, e.g. resolutions relating to the winding up of the company or repayment or reduction of its share capital. Types of preference. Shares, cumulative to non-cumulative, whether unpaid dividends accumulate, redeemable, irredeemable, whether they can be bought back by the company. All preference shares must be redeemable within 20 years, except for infrastructure projects which can be up to 30 years. Participating, non-participating, whether they share in surplus profits after paying equity shareholders. Convertible, non-convertible, whether they can be converted into equity shares. transfer, transmission, surrender, and forfeiture of shares. Transfer of shares, sections 56 to 59 CA 2013. Definition: voluntary transfer of title to shares from one person, transferor to another, transferee by way of sale, gift, etc. Procedure: execution of an instrument of transfer, Form SH4, by both transferor and transferee. Delivery of the share certificate, if physical, along with the instrument of transfer to the company. Board approval for registration of transfer, unless articles provide otherwise. In case of dematerialized shares, transfer occurs electronically through depositories, CDSL, and SDL. Refusal to register transfer. A company may refuse to register the transfer for sufficient cause but must send notice to the transferor and transferee within 30 days. The aggrieved party can appeal to the National Company Law Tribunal (NCLT). Transmission of shares, Section 56 CA 2013 read with rules. Definition: transfer of title to shares by operation of law, e.g., death, insolvency, lunacy of a shareholder. Procedure: legal heir or representative applies to the company with supporting documents, e.g., succession certificate, probate, letter of administration. No instrument of transfer is required. Key difference from transfer: transmission is involuntary, transfer is voluntary, surrender of shares. Definition: voluntary return of shares by a shareholder to the company. Legality: generally permissible only if it amounts to a forfeiture that the company could have validly enforced, e.g., to avoid a call on partly paid shares, or as part of a compromise or arrangement. It cannot be used to circumvent legal provisions relating to reduction of capital. Forfeiture of shares. Definition: compulsory termination of membership and cancellation of shares by the company due to non-payment of call money by the shareholder. Conditions: must be expressly authorized by the Articles of Association. Proper procedure must be followed, including notice to the defaulting shareholder. Consequences: shareholder ceases to be a member. Shares become the property of the company. Amount already paid on such shares is forfeited. Reissue: forfeited shares can be reissued at a discount, but the total discount cannot exceed the amount already received on the shares. But purchase by company of its own shares. Buyback, Section 68, Companies Act 2013. Definition: a company buying back its own shares or other specified securities from the open market. Existing shareholders on a proportionate basis, or through an employee stock option scheme. Purpose: to improve earnings per share, return surplus cash to shareholders, reduce outstanding shares, prevent hostile takeovers, or enhance shareholder value. Special resolution passed in general meeting if exceeding 10% but up to 25% of paid up capital and free reserves. Board resolution sufficient for up to 10%. Buyback limit not exceeding 25% of the total paid up capital and free reserves of the company. Debt equity ratio after buyback not more than 2:1. All shares and specified securities are fully paid up. Compliance with SEBI buyback of securities regulations 2018 for listed companies. No buyback if the company has defaulted in repayment of deposits, interest, dividend, or redemption of debentures, preference shares, or in filing annual returns/financial statements. Prohibition: no buyback through any subsidiary or investment company. IV: issue of shares at premium and discount. Issue at premium, Section 52, CA 2013. Definition: when shares are issued at a price higher than their face value. The excess amount is the share premium. Accounting: the premium amount is credited to a securities premium account. Utilization: the securities premium account can only be used for specific purposes: issuing fully paid bonus shares, writing off preliminary expenses, writing off commission or discount on issue of shares or debentures, providing for the premium payable on redemption of preference shares or debentures, for the purchase of its own shares or other specified securities. Buyback. Issue at discount, Section 53 CA 2013. General prohibition: a company cannot issue shares at a discount except for sweat equity shares. Section 54 Companies Act 2013. Shares issued by a company to its directors or employees at a discount or for consideration other than cash. for providing know-how or making available rights in the nature of intellectual property rights or value additions. Issue to creditors as part of debt restructuring. Consequences of illegal discount issue. The issue is void and the company and every officer in default are liable for a penalty. V. SEBI guidelines for share capital. SEBI issue of capital and disclosure requirements. Regulations 2018 ICDR regulations governs pricing, disclosure, allotment and other aspects of public issues. SEBI substantial acquisition of shares and takeovers. Regulations 2011 SAST regulations relevant when a substantial block of shares is acquired triggering open offer obligations. SEBI listing obligations and disclosure requirements. Regulations 2015 LODR regulations continuous disclosure requirements for listed companies affecting how share capital changes are communicated to the market. SEBI share-based employee benefits and sweat equity regulations 2021 governs the issue of sweat equity shares and employee stock options. SEBI buyback of securities regulations 2018 specific regulations for listed companies undertaking buyback of shares, ensuring investor protection and market integrity during the process. Unit 2 Shareholders and debentures. 1. Shareholders' rights. Shareholders, as owners of the company, possess a range of rights, categorized broadly as individual rights and corporate rights. Individual rights are right to receive share certificate, Section 46 CA 2013, to obtain a certificate for shares held. Right to transfer shares, Section 56 C 2013, subject to restrictions in articles for private companies. Right to receive dividends when declared by the company, Section 123 Companies Act 2013. Right to receive annual reports and accounts, Section 136 CI 2013, to inspect books and records within limits. Right to attend and vote at general meetings, Section 105 CA 2013 for proxy, Section 107 to 108 for voting. This is a fundamental right. Right to apply for bonus shares and rights shares when offered. Right to information access to statutory registers, e.g. Register of Members, Register of Charges. Right to participate in winding up, to share in surplus assets after creditors are paid. Corporate rights, collective rights exercised through voting. Right to elect directors, Section 152, California 2013, a crucial right to control the board. Right to remove directors, Section 169, Companies Act 2013, by ordinary resolution. Right to approve major corporate actions, alteration of memorandum and articles of association, Section 13, 14, CA 2013, special resolution. Increase in authorized share capital, Section 61, Companies Act 2013, ordinary resolution, but articles may require special resolution. Reduction of share capital, Section 66, Companies Act 2013, special resolution and NCLT approval. Buyback of shares, Section 68, CA 2013, special resolution for certain thresholds. Amalgamation, merger, takeover, Sections 230 to 232, CA 2013, special resolution. Winding up of the company, Section 271, 304 CA 2013, special resolution for voluntary winding up. Right to appoint and fix remuneration of auditors, Section 139, Companies Act 2013. Right to challenge oppression and mismanagement, Sections 241 to 246 CA 2013. If the affairs of the company are conducted in a manner prejudicial to the public interest or to the interest of the company or its shareholders. Right to demand poll, Section 109 CA 2013, to ensure votes are counted proportionately to shareholding. Right to convene an extraordinary general meeting, AGM. Section 100 CA 2013, if shareholders holding 1/10 of the paid up capital or voting power give notice. Variation of shareholders' rights, Section 48, Companies Act 2013. General rule, if a company has different classes of shares with distinct rights attached to them, these rights can only be varied if provision for such variation is contained in the memorandum or articles, or if not, then 75% consent of shareholders of that class is obtained. A special resolution is passed in the general meeting of the company. Dissenting shareholders, shareholders holding at least 10% of the issued shares of that class who did not consent to or vote for the variation may apply to the NCLT within 21 days of the resolution being passed. NCLT's role: the NCLT can disallow or confirm the variation. Its decision is binding. 2. Debentures. Debentures are a significant source of long-term debt financing for companies. Definition: Section 2, subsection 30, CR 2013. Includes debenture stocks, bonds, and any other instrument of a company evidencing a debt, whether constituting a charge on the assets of the company or not. It explicitly excludes instruments referred to in Chapter 3, public offer and private placement, which constitute a charge on the assets of the company or are redeemable within less than 12 months. Instruments issued by a company to raise deposits, kinds of debentures, secured debentures. Most common, debentures secured by a charge on the assets of the company. The company is required to create a debenture redemption reserve (DRR) and appoint a debenture trustee. Unsecured debentures, no charge on assets, rely on the company's creditworthiness. Redeemable debentures, redeemable at the end of a fixed period or on earlier notice. All debentures issued by Indian companies must be redeemable. Irredeemable perpetual debentures, rare in India due to regulatory requirements. No fixed date for redemption. Convertible debentures, fully convertible debentures, FCD, fully convertible into equity shares. Partially convertible debentures, PCD. A part is convertible, the rest is redeemed. Non-convertible debentures, NCD, cannot be converted into shares. Registered debentures, registered in the company's register of debenture holders, transferable only by a regular transfer deed. Bearer debentures, transferable by mere delivery. Interest is paid to the bearer. Remedies of debenture holders, appointment of debenture trustee. Section 71, Companies Act 2013 and Securities and Exchange Board of India, debenture trustees. Regulations 1993. Debentures are often issued with the appointment of debenture trustees who protect the interest of debenture holders. Suit for arrears of interest or principal if the company defaults on interest payments or principal repayment. Enforcement of security if the debentures are secured. The debenture holders or their trustee can enforce the charge on the company's assets in case of default. This may involve appointment of receiver to manage the assets and recover dues, sale of charged assets to realize the amount due, foreclosure, taking over the charged assets, application to NCLT for winding up of the company if it is unable to pay its debts, specific performance to enforce any specific covenants in the debenture trust deed, company charges, sections 77 to 87 CA 2013. Definition: a charge is a security created by a company over its assets, movable or immovable, present or future, to secure the repayment of a loan or performance of an obligation. It gives the creditor the right to have his debt satisfied out of the specified property in priority to other creditors. Types of charges: fixed charge attaches to a specific identifiable asset, e.g., land, building, specific machinery. The company cannot deal with the asset without the charge holder's consent. Floating charge attaches to a class of assets, e.g., stock in trade, debtors, plant and machinery that changes in the ordinary course of business. The company can deal with these assets until the charge crystallizes, becomes fixed upon a specified event, e.g., winding up, appointment of receiver, default. Registration of charges, section 77. Every company creating a charge must register it with the Registrar of Companies, ROCE, within 30 days of its creation. In Form CHG1 for other than debentures or Form CHG-9 for debentures. Extension of time for registration can be granted by the ROK up to 300 days or NCLT beyond 300 days. Consequence of non-registration: the charge is void against the liquidator and any creditor of the company. However, the underlying debt remains valid. Modification of charge: any modification of the terms or conditions of the charge must also be registered. Section 79. Satisfaction of charge: when the debt secured by a charge is repaid, the company must file a satisfaction of charge with the ROC Form CHG4 within 30 days. Section 82. Insider trading and SEBI 1. Insider trading, SEBI's guidelines on insider trading. Insider trading definition: it refers to the trading of a company's securities, shares, debentures, etc. by individuals who have access to unpublished price-sensitive information, UPSI, about the company, which, if made public, would materially affect the price of the securities. The trading is done before such information becomes public. Key elements: insider, any person who is or was a connected person or who is in possession of or has access to UPSI. Connected person includes directors, officers, employees, their relatives, auditors, legal advisors, bankers, fiduciaries, or any person associated with the company in a contractual fiduciary or employment relationship. Unpublished price. Sensitive information UPSI. Any information relating to a company or its securities directly or indirectly that is not generally available and which, upon becoming generally available, is likely to materially affect the price of the securities. Examples include financial results, dividends, mergers, acquisitions, demergers, major expansion plans, changes in key management personnel. SEBI Prohibition of Insider Trading, Regulations 2015, PITI Regulations. These regulations are the primary legal framework in India for preventing insider trading. Prohibition on communication or procurement of UPSI. No insider shall communicate, provide, or allow access to any UPSI except for legitimate purposes, performance of duties, or discharge of legal obligations. Prohibition on trading while in possession of UPSI. Insiders are prohibited from trading in securities when in possession of UPSI. Trading plans. Insiders can formulate a trading plan to execute trades in advance even if they later come into possession of UPSI, provided the plan meets certain conditions, e.g., duration of at least 12 months, no trading during certain blackout periods, disclosure to the stock exchange. Disclosure requirements, initial disclosures. Every promoter, key managerial personnel, and director must disclose their holdings within a specified period of appointment or formation of the company. Continual disclosures. Any change in holdings beyond a certain threshold must be disclosed. Disclosure by designated persons. Companies are required to identify and list designated persons, certain employees, directors, etc., who are generally privy to UPSI and are subject to specific trading restrictions and disclosures. Code of conduct. Every listed company and market intermediary must formulate a code of conduct to regulate, monitor, and report trading by its employees and other connected persons. Chinese wall policy. Companies are required to establish Chinese walls to prevent the misuse of UPSI by segregating departments handling confidential information from those engaged in sensitive activities. Whistleblower policy encourages reporting of suspected violations. Penalties. Violation of PIT regulations can lead to significant monetary penalties, up to rupees 25 crores or 3 times the profit made, whichever is higher, disgorgement of illegal gains, and even imprisonment under the SEBI Act 1992. 2. Securities and Exchange Board of India, SEBI, Constitution, Powers and Functions. Constitution SEBI Act 1992. Establishment. SEBI was established in 1988 as an interim administrative body and given statutory powers on January 30th, 1992 through the SEBI Act 1992. Composition: the chairman and 2 members from the Ministry of Finance, 1 member from the Reserve Bank of India, 5 other members appointed by the central government, of whom at least 3 shall be whole-time members. Powers and functions: SEBI Act 1992. Regulatory powers: regulating the business in stock exchanges and any other securities market. This includes regulating the entry and exit of participants, trading practices, etc. Registering and regulating the working of stockbrokers, sub-brokers, share transfer agents, merchant bankers, custodians, rating agencies, depositories, and other intermediaries. Registering and regulating the working of venture capital funds, collective investment schemes, including mutual funds. Prohibiting fraudulent and unfair trade practices relating to securities markets, prohibiting insider trading in securities, regulating substantial acquisition of shares and takeovers of companies, calling for information from, undertaking inspection, conducting inquiries and audits of the stock exchanges, intermediaries, and other entities in the securities market. Protective functions: protecting the interests of investors in securities, promoting investors' education and training of intermediaries, ensuring disclosure of adequate and accurate information by companies. Developmental functions: promoting and regulating self-regulatory organizations, promoting research and conducting inquiries for the purpose of efficient development of the securities market. Quasi-judicial powers. SEBI has the power to issue directions, pass orders, impose penalties, and adjudicate cases related to violations of the SEBI Act and regulations. Appeals against SEBI's orders lie with the Securities Appellate Tribunal, SAT. Another important topic is reconstruction, amalgamation, takeover, and auditors. 1. Reconstruction, amalgamation, and takeover provisions in company law and SEBI guidelines. These are significant corporate restructuring activities with profound implications for the company, its shareholders, and creditors. Reconstruction, internal. Definition: an arrangement by which the financial structure of a company is reorganized without external acquisition or mergers. It involves a fundamental change in the capital structure, often to deal with accumulated losses or to streamline operations. Purpose: to make the company financially sound, reduce capital, consolidate shares, or make capital more manageable. Provisions in company law, sections 230 to 232 CA 2013. Compromises, arrangements, and amalgamations often involves a scheme of arrangement approved by the NCLT. May include reduction of capital, section 66 Companies Act 2013, compromise with creditors, or variation of shareholders' rights. Requires approval by a majority in number representing 3/4 in value of the creditors or members, and subsequent sanction by the NCLT. The NCLT will consider whether the scheme is fair, reasonable, and for the benefit of the company. Amalgamation/merger, external. Definition: a process where two or more companies are combined to form a new entity. Amalgamation, or where one company absorbs another. Merger. Purpose: to achieve economies of scale, synergy, market expansion, diversification, or reduce competition. Types: amalgamation in the nature of merger. Pooling of interests, where substantially all assets and liabilities are transferred and shareholders of the transferor company become shareholders of the transferee company. Amalgamation in the nature of purchase. One company acquires another. Provisions in company law, sections 230 to 232, CI 2013. Scheme of amalgamation merger requires a comprehensive scheme to be formulated. Application to NCLT. The companies apply to the NCLT for directions to call meetings of creditors and members. Approval by creditors and members. Approval by a majority in number representing 3/4 in value of creditors and members of each class, present and voting. NCLT sanction. The NCLT scrutinizes the scheme for fairness, public interest, and compliance with law. Once sanctioned, it becomes binding on all stakeholders. Fast track mergers, sections 233 CA 2013. Simplified procedure for merger of wholly owned subsidiaries or small companies without NCLT approval, subject to certain conditions and a central government approval. SEBI guidelines for listed companies. LODR regulations require listed companies to make specific disclosures regarding mergers, amalgamations. ICDR regulations, relevant if the merger involves a fresh issue of shares. SAST regulations may be triggered if the merger results in a change of control. Takeover. Definition: the acquisition of control over a company by another company or person through the acquisition of a controlling stake in its shares. Types of friendly takeover: when the target company's board of directors agrees to the acquisition. Hostile takeover: when the target company's board resists the acquisition and the acquirer attempts to acquire control directly from shareholders. Provisions in company law. While the Companies Act broadly deals with substantial acquisition of shares, the specific regulations for takeovers are primarily under SEBI. SEBI, substantial acquisition of shares and takeovers. Regulations 2011 SAST regulations. These are the most critical regulations governing takeovers of listed companies. Trigger points: acquisition of 25% or more of voting rights in a target company. Acquisition of control over a target company, irrespective of voting rights. Any acquisition of shares that increases holding beyond 25% by 5% or more in any financial year. Creeping acquisition. Mandatory open offer. Upon reaching a trigger point, the acquirer is obliged to make an open offer to the public shareholders of the target company to acquire an additional 26% of the voting shares at a specified minimum offer price. Purpose of open offer: to provide an exit opportunity to public shareholders at a fair price in case of a change of control. Disclosures, extensive disclosure requirements at various stages of the takeover process. Due diligence permissible only under specific circumstances. Role of manager to the offer. A SEBI registered merchant banker acts as a manager to the open offer. 2. Auditors. Auditors play a crucial role in ensuring the financial integrity and transparency of a company. I. Appointment, powers, duties and removal of auditors. Appointment, sections 139 to 140, CA 2013. First auditor, government company appointed by the Comptroller and Auditors General of India, CAG, within 60 days of incorporation. If CAG fails, board within next 30 days, then members in EGM within 60 days. Non-government company appointed by the board of directors within 30 days of incorporation. If board fails, members in EGM within 90 days. Subsequent auditor, government company appointed by the SAGI within 180 days from the commencement of the financial year. Non-government company appointed by members at the annual general meeting AGM for a term of 5 years, individuals or 10 years firms, subject to ratification at each AGM. Casual vacancy filled by the board within 30 days. If due to resignation, members must approve within 3 months. Rotation of auditors. Section 139, subsection 2, CA 2013. Mandatory for certain classes of companies, listed, unlisted, public companies with certain paid up capital, private companies with certain paid up capital. An individual auditor cannot be reappointed for more than one term of 5 consecutive years, and an audit firm for more than 2 terms of 5 consecutive years. Powers of auditors, section 143, CA 2013. Right of access to books of account and vouchers of the company at all times. Right to information and explanation, to require from the officers of the company such information and explanation as he may think necessary for the performance of his duties. Right to attend general meetings, to receive all notices and other communications relating to any general meeting, and to attend any general meeting and be heard on any part of the business which concerns him as auditor. Right to report to members, to make a report to the members on the accounts examined by them. Right to inspect branch accounts if the company has branch offices. Duties of auditors is section 143 CA 2013, to make a report to the members on the accounts examined by them, containing details of every financial statement laid before the company in AGM, to state whether, in their opinion, and to the best of their information and according to the explanations given to them, the said accounts give a true and fair view of the state of the company's affairs, its profit or loss, and its cash flow, to inquire into various matters, whether loans and advances made by the company have been properly secured, whether transactions represented by book entries are prejudicial to the interest of the company, whether investments are held in the company's name, whether personal expenses are charged to revenue account. Duty to report on fraud, section 143 subsection 12, CA 2013. If the auditor has reason to believe that an offense of fraud involving such amount as may be prescribed is being or has been committed against the company by officers or employees, the auditor must report to the central government if exceeding prescribed amount, or to the audit committee Yastop board if below prescribed amount. Compliance with auditing standards. To comply with the auditing standards prescribed by the central government in consultation with the National Financial Reporting Authority, NFRA. Reporting on internal financial controls. For listed companies and certain other companies, auditors must report on the adequacy of the internal financial control system over financial reporting and the operating effectiveness of such controls. Removal of auditors, section 140 CA 2013. Before expiry of term, requires previous approval of the central government delegated to RD and a special resolution of the company. Resignation. An auditor who has resigned must file a statement with the company and ROC within 30 days in Form A DT3. Removal by tribunal, NCLT. If the NCLT is satisfied that the auditor has acted in a fraudulent manner or abetted or colluded in any fraud, it may order the company to change its auditor. The central government can also make an application. Special audit, section 142 subsection 7, CA 2013 read with rules. Definition. An audit ordered by the central government if it is of the opinion that the affairs of the company are not being managed in accordance with sound business principles or prudent commercial practices, or that the company is being managed in a manner likely to cause serious injury or damage to the interest of the trade, industry or business to which it pertains, or that the financial position of the company is such as to endanger its solvency. Purpose: to investigate specific aspects of a company's operations or financials. Appointment: the central government appoints an auditor, not necessarily the company's regular auditor, to conduct the special audit. Scope: the order specifies the scope and period of the special audit. Report: the special auditor submits a report to the central government. The central government may then take appropriate action based on the report. Director responsibility. Statement in board report, section 134, subsection 5, CA 2013. Purpose: this statement is a crucial part of the board's report, which accompanies the financial statements and enhances corporate governance by fixing accountability on directors for the preparation and presentation of financial statements. Contents: the board of directors report shall state that the directors have, in the preparation of the annual accounts, followed the applicable accounting standards and explanations, have selected such accounting policies and applied them consistently, and made judgments and estimates that are reasonable and prudent so as to give a true and fair view of the state of affairs of the company at the end of the financial year and of the profit and loss of the company for that period. Have taken proper and sufficient care for the maintenance of adequate accounting records in accordance with the provisions of this Act, for safeguarding the assets of the company, and for preventing and detecting fraud and other irregularities. Have prepared the annual accounts on a going concern basis. Have laid down internal financial controls to be followed by the company, and that such internal financial controls are adequate and were operating effectively. Have devised proper systems to ensure compliance with the provisions of all applicable laws, and that such systems were adequate and operating effectively. National Advisory Committee on Accounting Standards, NACAS. Background and establishment: the National Advisory Committee on Accounting Standards, NACAS, was constituted by the Central Government of India under Section 132 of the Companies Act 2013. Earlier Section 210A of the Companies Act 1956. Its primary role is to advise the central government on the formulation and laying down of accounting standards. Purpose and objective: the main objective of NACAS is to ensure the quality, transparency, and comparability of financial reporting by Indian companies. It plays a crucial role in the development and adoption of accounting standards that align with global best practices, specifically the Indian Accounting Standards, INDA-IS, which are converged with the International Financial Reporting Standards, IFRS. Composition: NACAS comprises a diverse group of members with expertise in various fields related to accounting, finance, and corporate law. Typically, its members include chairperson, appointed by the central government, representatives from various government bodies, such as the Ministry of Corporate Affairs, MCA, Comptroller and Auditor General of India, CAG, Reserve Bank of India, RBI, Securities and Exchange Board of India, SEBI. Representatives from professional bodies like the Institute of Chartered Accountants of India, ICAI, Institute of Cost Accountants of India, Indian Company Secretaries of India, Institute of Company Secretaries of India. Representatives from industry and academia. Individuals with significant experience and knowledge in accounting and finance. The diverse composition ensures a comprehensive perspective and expert advice on accounting matters. Powers and functions. The key powers and functions of NACAS include advising on accounting standards. Its primary function is to advise the central government on matters relating to the formulation and laying down of accounting standards for adoption by companies or class of companies under the Companies Act 2013. Recommending standards. NACAS examines the recommendations made by the Institute of Chartered Accountants of India, ICAI, on accounting standards and provides its views to the central government. The ICAI plays a significant role in developing the initial drafts of accounting standards in India, ensuring convergence with global standards. A major focus of NACAS has been to facilitate the convergence of Indian accounting standards with IFRS. It advises on the necessary modifications and adoptions to achieve this convergence, review and amendment. NACAS also reviews existing accounting standards and recommends amendments or new standards as and when required, based on changes in business practices, economic environment, or international developments. Promoting good accounting practices. Through its recommendations, NACAS aims to promote transparent, reliable, and comparable financial reporting practices across Indian corporates, which in turn enhances investor confidence and corporate governance. Process of standard formulation. The process generally involves drafting by ICAI. The ICAI, through its Accounting Standards Board, ASB, develops exposure drafts of accounting standards. Public comments. These drafts are then exposed for public comments from various stakeholders. Review by NACAS. NACAS reviews the final recommendations of the ICAI considering all stakeholder feedback. Advice to central government. NACAS then advises the central government, which ultimately notifies the accounting standards. 6. Significance in corporate law. NACAS plays a vital role in the corporate legal framework in India by ensuring compliance. The accounting standards recommended by NACAS and notified by the central government are legally binding on companies, thus ensuring a standardized approach to financial reporting. Investor protection. By promoting robust accounting standards, NACAS indirectly contributes to investor protection by providing them with reliable financial information to make informed decisions. Facilitating corporate governance. Transparent accounting is the cornerstone of good corporate governance. NACAS's work strengthens this aspect. Global integration. Its focus on India's IFRS converged standards helps Indian companies compete globally and facilitates cross-border investments. Thank you for watching.